We have a big decision that was just decided in court, and that is Witkowski versus Collins, the VA. Okay. I'm going to link this down below if you are one to read court orders. I am not. Luckily, we have CCK here who has covered this, and they even have a section on why it matters for veterans, and that's really the big takeaway here. Okay. So what we're going to do is just go through this. CCK law secures landmark victory in Witkowski versus Collins. Court overturns Bowling v. Principe, former VA secretary. So just VA. Okay, these are just the VA. And restores board authority over extra scheduler TDIU. Just came out November 14th. CCK does great work. They're an accredited law firm. And they really do fight for veterans, both individually and on like the big stage like we see here. So cool beans to CCK. Now, in October 25, the U.S. Court of Appeals for Veterans Claims issued a sweeping en banc. I don't even know what that is. That's why we're on CCK's website to begin with. All right. Decision in Witkowski v. Collins. This ruling, argued by CCK attorney April Donahauer, I apologize if I pronounced that wrong, overturns more than 20 years of precedent and removes a major source of procedural delay for veterans seeking TDIU on an extra scheduler basis. It's crazy because there are many people out there that want to take away IU altogether. So, good win. The court explicitly overruled Bowling v. Principe, ending the long-standing requirement that the Board Veteran Appeals, BVA, must first send extra scheduler IU cases to the Director of Compensation before deciding them. For countless veterans, this change means faster decisions, fewer procedural dead ends, and a fairer path to benefits. This is a big one here. Fairer path. This case is also an example of CCK law's philosophy and systemic advocacy. Each case is prepared meticulously, and every argument is developed as though the case may one day be presented before a court. You know, this reminds me of that meme. It's like a high school meme whenever it's like the class clown is all fun. It's all fun and games until they have to read out loud. That's what I feel like right now. Anyways, if a case exposes a recurring regulatory problem that harms tens of thousands of veterans, CCK aims to be ready to fix that problem, not only for an individual client, but for all veterans who rely on this system. Blows a breakdown of what happened in Witkowski, what the court held, and why the decision matters. So here's the background. For more than 2 decades, Bowling required the board to follow a rigid 2-step process for extra scheduler IU. If a veteran did not meet scheduler IU criteria, but evidence showed unemployability due to service-connected disabilities, the board had to refer the case to the Director of Compensation for an initial opinion. Only after the director issued a decision could the veteran return to the board for appellate review. In practice, this mandatory detour caused years of delay. The director usually denied these referrals, and the process duplicated adjudication that the board could otherwise have completed in a fraction of the time. Veterans routinely waited several additional years after a referral before the board could make a final decision. Under AMA procedures, the appeal thing, referral also forced many veterans to file a new notice of disagreement, sending the case back to the end of the appellate line. This system trapped veterans like Mr. Witkowski, a Vietnam-era Navy veteran seeking the earliest possible effective date for IU based on hearing loss. I wonder how much back pay this dude got. Although evidence showed unemployability from the date of his claim, the board believed that Bowling prevented it from granting IU before June 21 without a referral. Because Mr. Witkowski explicitly waived referral and asked for a decision based purely on the evidence, the board denied earlier period outright, allowing the issue to be appealed by the Court of Appeals for Veterans Claims. This set the stage for the court to address questions about jurisdiction, regulatory interpretation, and procedural fairness. I don't even know what I read, to be honest with you. I hope that makes sense to you. I'm going to read these highlights, and then we're just going to go to why it matters to veterans. How about that? Only Congress can limit board jurisdiction. The regulatory text never applied to the board, and these are CCK's winning arguments. Okay. The court's hearing, Bowling's overruled. Okay, that's the win there. And then why the Witkowski decision matters for veterans. 1, faster decisions and elimination of mandatory referral delays. Veterans seeking extra schedular IU will no longer face a procedural loop that delays adjudication for years. The board can weigh evidence and issue its own decision directly. This is awesome. When you think of TDIU, all right, I would argue that this is like the most vulnerable veteran population. And you couple that with being a Vietnam era veteran, I think it only makes that case stronger. So congrats to this guy. Greater consistency in IU outcomes. Previously, 2 veterans with identical evidence could experience different procedural outcomes depending on whether referral was ordered. This decision restores uniformity and consistency across cases. 3, stronger access to judicial review. Under Bowling, veterans had to navigate a multi-step process that made meaningful review difficult. Now the board must address extra schedular TDIU directly, creating a clear record for appeal and judicial oversight. And 4, system-level impact beyond a single case. This ruling affects not just Mr. Witkowski, but potentially hundreds of thousands of veterans who have raised or will raise extra schedular IU. It also improves administrative efficiency for VA employees who struggle with procedural complexity created by Bowling. I'm going to link this below as well. So you're in the pinned comment, you're going to see this article by CCK. You're going to see the order here in the pinned comment. And if you're facing appeals, especially for really, really difficult cases, there is a time and place to consider getting an accredited VA attorney. This would be one of them. But yeah, that's all I got. Good work, CCK. We appreciate it.